This gets into the dynamics of everything with Lafayette County and the state of Mississippi, the actual pure negligence, the culpable negligence, and the recklessness of everything. The Fourth Amendment, incorporated to apply to the states through the 14th Amendment, Baker v. McCollum, protects individuals against unreasonable seizures. U.S. Constitution, Amendment 4. Because they involve unreasonable seizures, constitutional claims for false arrest against state public officials arise under the Fourth Amendment. See Carter v. Butts County. An arrest is a seizure. Claims of overdetention under 1983, 42 U.S. Code 1983. Claims of overdetention can arise under the Fourth Amendment's right to be free from detention without probable cause, or under the 14th Amendment's substantive due process right to be free from continued detention after it should have been known that the detainee was entitled to release. See at 952, also see Canning v. Macon County. Proving a violation requires a plaintiff to establish that the defendant was deliberately indifferent to his due process rights. I think I've proven that there's been a deliberate indifference since day one. To satisfy that standard, a plaintiff must show three things. One, the defendant's subjective knowledge of a risk of serious harm in the form of continued detention even after the plaintiff had a right to be released. Two, disregard of that risk. And three, disregard by conduct that is more than mere negligence. Failure to take any steps to properly investigate and identify the claims made on affidavit to be grotesquely false in nature is sufficient to raise a question of fact as to his deliberate indifference towards Reardon's due process rights. Numerous courts have also reached the almost tautological conclusion that an individual in custody has a constitutional right to be released from confinement after it was or should have been known that the detainee was entitled to release. This is their job. They're supposed to know this, especially when it comes to the liberties and the freedoms of assumably innocent American citizens. Depending on what procedures the state affords defendants following arrest and prior to actual trial, mere detention pursuant to a valid warrant but in the face of repeated protest of innocence will, after the lapse of a certain amount of time, deprive the accused of liberty. Now, without due process of law. Question is, what is that certain amount of time? I sat in jail for 6 weeks' time. 3 manifest errors, actually more than 3. I should have been released no more than 14 days in. I should have gotten an initial hearing within the first 48 hours. A refusal to legislate equally for the protection of all would unquestionably be a denial of equal protection. This conceded, upon what ground can it be pretended that a refusal to execute or a failure to do so through inability, equally with reference to all persons, is not also a denial? I maintain, therefore, that the true meaning of this constitutional provision is that the state shall afford equal protection to all persons within its jurisdiction. Failing to do this, whether that failure is the result of inaction or inability on the part of the one or the other of the coordinate branches of the state government, the remedy lies with Congress. Whenever it appears that any state has failed to discharge this high constitutional obligation to all its citizens, it is not only within the power, but it is the solemn duty of Congress to enforce the protection which the state withholds. And that right there is my justification. It's the reason why I've called multiple congressmen and senators, and I have demanded that this particular fiasco is required of congressional oversight. There needs to be a congressional hearing. Congress enacted the predecessor of Title 42 U.S. Code 1985, which prohibited private conspiratorial conduct. Congress recognized that men who go undisguised upon the public highway or upon the premises of another are not likely to be acting in official capacities. The 42nd Congress believed it had both the constitutional power and the obligation to prevent private conduct from interfering with the guarantees of the 14th Amendment, United States v. Williams, cited in Griffin v. Breckinridge. Griffin v. Breckinridge, the court articulated a clear position that Section 1985, Paragraph 3, was a remedial statute that was constitutional on its face and that reached private conspiracies to deprive citizens of civil rights. The court stated that 1985, Paragraph 3, reaches private conspiracies to deprive others of legal rights can, of itself, cause no doubts of its constitutionality. Thus, according to Griffin, state action is not required in order to bring a suit under Section 1985. Yet, if the constitutional right that is violated is the right to equal protection of the laws, Section 1 of the 14th Amendment indicates that those rights are violated only if a state shall make or enforce any law which denies to any person within its jurisdiction the equal protection of the laws. Through this reasoning and interpretation, the state must be involved in order to find a 14th Amendment violation. As such, plaintiff brings forward his claims against the state of Mississippi and each official named within for their full knowledge of aggrieved violations. Lafayette County, Mississippi, and its officials named within for their full knowledge of aggrieved violations. And plaintiff alleges that the defendants conspired upon efforts with certain individual private citizens to hinder the plaintiff's right to vindication through the intentional initiation of frivolous and knowingly perjurious legal proceedings, and further refusing him the equal protections of the laws guaranteed under the 14th Amendment. In turn, the state of Mississippi, through denying the plaintiff the equal protections of not only its own laws laid out, but federal constitutional rights as well, have continued to deny plaintiffs absolute right to redress and vindication. Plaintiff alleges that there exist multiple examples of this now, and that evidence would demonstrate a continued repetitive effort that the state of Mississippi, and in particular Lafayette County and Lafayette County Sheriff's Department, have demonstrated an undeniable pattern of the same occurrences and conduct, leading directly to an ultimate end goal of the defendants absconding with their prior immoral, unlawful, and unconstitutional acts, further intending to seek indemnification for intentional liabilities by inflicting fear and pressure into the plaintiff so that he caves and gives in. It's the continuation of the latter that plaintiff alleges constitutes violations under the RICO Act, and as such, plaintiff alleges RICO Act violations in his complaint.